All right, this is case number 21-61244. This is Westlake Services LLC versus Nicole Whitaker. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered on the 25th of March 2021. $7,066. This is an attempt to collect in filed as to CD.
That's what you're writing down.
CBS firm. Please mute yourself until I ask you to unmute yourself. Your appearance for Westlake Services LLC, please. Westlake Services LLC. One moment here. I'm going to recall that matter in just a moment. All right, the court is calling now case number 21-165-777. This is Mobile MRI Staffing LLC versus City of Detroit. The matter is set for a pretrial conference at this time. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Joe Yatuma on behalf of the plaintiff.
All right, thank you, Mr. Yatuma. Your P number for the record, if you will.
P80627.
All right, thank you, counsel. Good morning to you. For the City of Detroit, your appearance at this time, please.
Your Honor, Sarah Doman, P79128 on behalf of defendant.
All right, thank you, Ms. Dolan. Good morning to you as well. The latest that I see in the file has something to do with the substitution of counsel. And I see that Ms. Domain is, I believe, the person that's subbed in. Is that about the size of it?
Yes, Your Honor, I subbed in for my colleague Robin Brooks in mid-January, probably.
All right, got you. Okay, so what's going on in this matter? I do have it set on for a pretrial. I think I previously gave a scheduling order regarding this matter as well. Talk to me, Madam Counsel, and I'll come to you, Mr. Yatuma.
Yes, Your Honor. It looks like discovery was open until today. I'm looking at the file. I'm not sure if defendant issued any discovery in this matter. I guess we're in the process of, we filed our initial disclosures, and I guess we're in the process of hoping to resolve this.
All right. Ms. Domain, have you gotten up to steam on this one? I know you stepped in January. Go ahead, ma'am.
Yes, Your Honor, and I think that I can definitely speak with Mr. Yatuma. I think at this point, probably if the court would schedule us for a settlement conference at some point in the future, I think we should be able to have some discussions between now and then.
All right, I was going to send you to a breakout room today. Do you think any discussions today would be fruitful, potentially?
We can talk.
All right, so I'm going to, I'll be here, so I'm going to send you away to try it out, and you know what to do, and if you can get some things done, that'll be very good, and then we'll come back and address any issues. So, Mr. Yatuma, there is your notification.
Thank you, Judge.
I'm getting to you here. There we are. All right, I'll talk with you shortly. The court now calls case number 21-167-724. This is Mobile Group versus Victoria Williams. The matter is before the court, having been set on before the court with regard to an answer having been filed to the complaint in this matter. For Auto Club Group, your appearance at this time, please.
Good morning, Your Honor. Dylan White, P80755 for Velo Law Office, representing Auto Club Group.
All right, thank you, Mr. White, and good morning to you, sir. For defendant Victoria Williams, do I have Victoria Williams or someone representing Ms. Williams? Thank you. I see that Ms. Williams is present in the court. Your state.
Sorry, Your Honor, I can see that you're speaking, but I can't seem to hear you.
I'm here and I can't hear either.
Right, Judge, and something has happened to your screen. You're very small now.
Is that right? We don't have to.
Now I can hear you.
We can hear you, but you know, you're very small, so.
Well, I can't be a small guy here. We have to check that. We'll see what we can do. Just kind of target. Yeah, that's good right there. Yeah, we don't have to do things.
Okay, that'll work.
All right. So yeah, counsel, update me on this, Mr. White.
Well, it looks like this is our first pre-trial. Proof of service was good on both defendants here by a certified mail on January 6th. We've received an answer from defendant Victoria Williams, but not from defendant Monique Moses. And in fact, we actually have a default on defendant Monique Moses that was just entered in on the 8th of March here.
Got it. The nature of your claim, just so that we can put that on the record, sir. The nature of
Auto
your claim,
subrogation claim. Sorry, Your Honor.
all right. And ma'am, you understand the nature of the claim that's been brought against you. That is that some funds were paid out as a result of damage arising out of an accident, and they're seeking to subrogate that. They're seeking to give recovery of the money they paid out, damages to vehicle involved in an accident that you were involved in. You understand that? That's I didn't ask you that, did I? Did I ask you that? All right. Do you understand the nature of the claim? That's the question I'm asking. All right. So you did file an answer to this. So the next step in this process is what's called a discovery process, and that is for the exchange of information. You will have the right, as well as the other side will have the right to issue requests for information. Sometimes those things are called interrogatories, where you send a set of questions. You may receive a set of questions. Depositions can be taken, and requests to admit certain things can be submitted by you, and you can receive the same from the other side. All of this is an effort to try and narrow the issues and try to get to the bottom line as to what the rights of the parties need to be, what the obligations of the parties. So this is a claim, a separation claim, wherein plaintiff is claiming that as a result of an automobile accident that you were in, that's what you're claiming, that there are damages that were paid out to repair or correct something that occurred in that accident. You understand that that's the claim, right? Counsel, did I state generally the nature of the claim correctly, sir?
Yes, you did, Your Honor.
All right. So I'm going to go ahead now and set up a calendar for the exchange of information. And Ms. Williams, you have the right, of course, to send in writing any documents that you might want to request. They will be sending to you requests for certain documents, for certain information, to admit or deny things. You have to respond to those items. Otherwise, they become a matter of default. You understand?
Yes.
All right. So what I'm going to do is over the next, I will allow that process to take place over the next 60 days. And so the next hearing date in this matter is going to put us in May. That's going to be May.
You said 60, May 16th.
Right, can we do it just a little bit further than 60?
You want the 23rd?
All right, May 23rd is going to be the next date that you're going to be in front of me, May 23rd. I will leave discovery open through May 23rd. That means that parties can request information from each other, exchange information through May 23rd, 2022. The next hearing in this matter is going to be at 9:45 a.m. I also allow, as I will in this case, the filing of motions. That is, if you wish to file something with the court, a motion to dismiss, a motion for entry of judgment, motions that may decide the case, or a motion for clarification, a number of different requests that can be filed before the court. You can file any motion and set it for hearing, dispositive or non-dispositive, and set it for hearing on the 3rd at 9:45, May 23rd, 9:45. The only requirement is that the other side has to have at least 10 days notice prior to the hearing date. File a motion, as long as the other side has 10 days to respond, I will hear the motion on the 23rd of May. So file your motion, you can set it for hearing on 5/23/22. One requirement is that you got to make sure you give the other side at least 10 days to respond to that motion. This allows for the filing of motions even in a shorter time frame than would normally be allowed under the court order. So the court, by its order, is setting a shorter time. If you wish to file any motion, I'll hear it on that day. Now I'm going to generate a written document that is going to set forth the scheduling order. Ms. Williams is going to receive a copy before she leaves today. And council, we're going to send a copy to you as well. The key thing to remember: discovery is open through May 23rd, 2022, and that motions can be heard on that date, so long as those motions are filed early enough to give the other side at least 10 days to respond to the motion. Right? That's my order regarding this case. You'll get a copy shortly, ma'am, and council will make sure you get a copy.
Thank you, Your Honor.
Excuse me, Your Honor.
Who's that?
Monique Moses.
All right. Did I call your case?
Yes, you just got through talking about my case.
Oh, you're in default on that case because you.
Okay, how do I go back?
Yeah, what you need to do, unless council is willing to stipulate to set it aside, what you need to do is file a motion asking that the default be set aside. There's a document on the second floor of the building. It's a motion to set aside default, and state the reason why you didn't file the motion in the timely way. You have to show good cause, and then point out what you raised as your defense. You have to show good cause. Why didn't I file on time? And then secondly, why I have a defense in this case, what my defense is. File that on the second floor, and it will come in front of me, and then I will take a look at it and set a hearing so that we can review this matter and see if there is a basis to set the default aside. Understand?
Yes.
All right. All right. I didn't know that you were there, and I don't even see your name coming up now because it's earlier in the file because of that default procedure. So make sure you go and file something on the second floor so the court can address that issue. Understand?
Yes.
All right. I wish you well, Ms. Moses. Good day to you.
You too, sir. Thank you.
And I'm back on the record with regard to the suffix 777. Thank you, thank you, Mr. Domain, and thank you, also Mr. Yatuma. I saw you back there somewhere. There you go. All right.
Yeah.
Thank you for taking the time to go into the breakout room to at least begin a discussion regarding this case. And somebody update. Mr. Yatuma?
Yes, Your Honor. We're still in the process of exchanging some more information here and trying to get some more authority from our clients. So if we may ask the court to probably adjourn this for another 60 days, we'd appreciate it. Hopefully we can have a resolution by then.
Thank you, Mr. Yatuma. That makes sense to you, Ms. Domain?
Yes, Your Honor, that's correct.
All right, very well. So we'll set it out approximately 30 days out, and I'll set it for a settlement conference at that time. I'll take a look at everything and see where you are.
26.
4/26/22, 4/26/22 at 9:30 a.m. That's the next action date in this matter. 4/26/22, 9:30 a.m.
Roger that. Thank you, Your Honor.
Thank you, Your Honor.
Have a good day.
You too.
The court now calls case number 21-168-087. This is Huron Case Management versus City of Detroit. The matter is before the court settled for a pretrial conference. The court did set a scheduling order regarding this case and allow for completion of discovery 90 days to date. Your appearance for Huron Case Management, please.
Your Honor, Michael Xavier on behalf of Huron Case Management.
Go ahead and put your P number on, if you will, Mr.
P-
Xavier.
P76438, Judge.
All right, thank you, sir. Good morning to you. For the city of Detroit, your appearance at this time, please.
Good morning, Your Honor. Philip Hiltner for Defendant City of Detroit, P77913.
Thank you, Mr. Hiltner, and good morning to you as well, sir. So go ahead and update me on where you are with regard to discovery. Have you began talking about whether it's possible to get this resolved? Somebody go ahead and talk to me.
Judge, the parties have exchanged discovery. It's only been about 45 days since the first pretrial hearing, and both parties did exchange responses. We require the full claim file. In order to do that, it sounds like we'll have to provide defense counsel with a protective order, which I provided him this morning. Was my proposed language, just so we could get the full claim file for the claimant released. All I need is the full claim file. That's what remains on my discovery, Judge. That my written discovery is done. I just need the rest to be produced. So essentially, I just need a little more time, however long Mr. Hiltner thinks it'll take to produce it.
All right. So have the two of you been able to agree on the language as it relates to the protective order in this regard?
We have not, Your Honor, but we just started. This just came up this morning. Both sides exchanged discovery yesterday. I requested an authorization just from the claimant, Ms. Shannon, so that we could disclose the complete claim file. I haven't even taken a close look at the protective order, if that'll work. I don't know. We'll have to discuss that and go from there.
All right. And counsel, Mr. Xavier, you have any control over the city's request, if you will, for authorization from the claimant?
Your Honor, as the claimant's case management company, there's already a signed HIPAA release as part of our records, and they've been produced to the city of Detroit. So I'm not sure what other type of authorization would be required, as we've been getting all of her medical records for the last year and a half.
Yeah, I would just respond that if he has an authorization, great. His discovery responses were 450 pages, so I just haven't had a chance to go through every page. But if there isn't one, then I don't see why it would be an issue for him to get one from Ms. Shannon if they're still treating. So I think that would be probably the easiest way to resolve this.
All right, very well. So what I'm going to do is I need to see this move a little bit. I really appreciate the fact that the respective counsel in this matter moved forward in requesting and exchanging information. I don't want this hiccup here, although a significant one, to stop things from flowing such that they would hinder us from reaching critical horizons in this case. So I want to bring it back about 30 days now, just to take a look at this and make sure that we're zeroing in on this issue regarding the exchange of information records, protect. So I'm going to go ahead and set you an early date to come back, just beyond 30 days out, and that's going to put us in April
the 27th.
The 27th, 3/27, 4/27, sorry, 4/27, 22, and that's going to be at 9:45 a.m. That's an adjourned pretrial date. Court's going to review issues of discovery at that time. It's 4/27, 22 at 9:45.
Thank you, Judge.
Good day to you.
Thank you.
Thank you, Your Honor. Take care.
Ms. Williams, I'll mail you your order when the judge completes it, okay?
All right, sorry, I didn't get to it as quick as I wanted, but I'll complete it, and then she'll get right in the mail too.
Yes.
Okay.
I said y'all gonna email it to her?
No, we'll mail it to you.
Mail it. Okay, mail it.
All right, court now calls case number 21-61244. This is Westlake Services LLC versus Nicole Whitaker. Matters before the court on a writ of garnishment arising out of a judgment that was issued on the 25th of March 2021. That judgment amount was $7,066.99. All right, your appearance for Westlake.
Good morning, Your Honor. Alexander Sarhan, P77252, on behalf of plaintiff.
Thank you, Mr. Sarhan. Good morning to you. I'm looking now for Nicole Whitaker, please. If you're on the Zoom, please say something at this time.
Good morning, Your Honor.
Good morning. That don't sound like no.
Good morning.
Or do I have counsel?
I'm here. I'm here representing my wife.
Okay. Are you a lawyer?
No, I'm not.
Well, you can't represent your wife. Is your wife here?
Yes, here I am.
I'm appearing specially, not generally, as intervener on behalf of my wife.
And you can't do that. So yeah, you understand that. That's okay. Good morning to you, Miss Whitaker. All right. So this is your objection to the writ of garnishment, and I noticed that you indicated that you never were served with the writ, was not able to properly defend yourself. It was without notice is what you put on the document. Is that correct, ma'am?
Your Honor, I'm speaking for her. She's my wife.
I understand that by your articulation that you do not have a learning disability. It's very clear to me. You already heard me tell you that you can't do that. Now you heard me tell you that. So we're not going to go back and forth. We're not going to go back and forth about that because you can't do that. That's all that is. You can't do that. You just can't. All right, now if you want to
How can I?
Okay, now if you want to do that, then what you do is the two of you go in a room somewhere and talk about it, and then you come back and let her talk about whatever she wants to talk about. But you can't represent her. You can't do that. Now that's like 5 or 6 times I said that, and you already understand. I don't think that there's anything wrong with you intellectually. It's that you don't like the answer, and that's okay. I'm okay with that. Okay that you don't like the answer. You still can't represent her. Is that okay with you? You understand that?
Okay, why can I represent my wife? A man is supposed to.
Here's what I'm going to do. I muted you, and Miss Whitaker, if you don't want to speak on your own behalf regarding this particular case, then it will be treated as if you're absent, and there will be no action taken on the objection to garnishments, which means the garnishment will stay in place. I don't think that that's the result that you want. But if you're not going to speak up on a case that you have, I don't care if your husband consults with you, he can tell you what he wants to tell you in his ear, in your ear, or whatever he wants to do. He just can't represent you. He's not a lawyer. He can't do it that way. And listen, I'm married too. You guys can talk about it and do whatever you want to do about it. He can't represent you. You can't do that. Otherwise, the law would say that lawyers. You have to have a lawyer to do this, that, and the other. But if you happen to be married, then that your spouse can be your lawyer. That's not true. It's just not. And now you're wasting my time. So I'll come back to this case as you think about what you want to do. Counsel, I hate to hold you up on this, but the other side is she may have something that she wants to raise here. It looks like she's saying something that may affect the underlying case in this matter. But it also may be something where.
It's fine, Your Honor. We can proceed.
No, I don't want to hear from you because you're working on something that is really disturbing me because I have other cases to deal with, and you want to sit there and act like you can't understand what I'm saying for 5 or 10 minutes to just waste time. I'll come back to you, counsel. I apologize for your time. This is case number 21-150013. This is Visiting Angels Living Assistant versus Kenneth Wesley. The matter is before the court. Looks like there has been the filing of an answer in this matter. Your appearance for Visiting Angels, please.
For the record, Your Honor, I'm Jim Washington. I represent Visiting Angels.
All right, thank you, Mr. Washington. Give me your P number for the record, please, sir.
My P number is P42503, Your Honor.
All right, thank you, sir. And now I'm remembering this case. Madam Counsel, your appearance for the defendant in this matter, please.
Good morning, Your Honor. Thomasine Jefferson on behalf of Kenneth Wesley, P42870. I think they're on the phone.
All right, thank you. Are you, if you're here, say good morning, Mr. Wesley or Miss Wesley or whoever is there. All right, the last time we were here, I don't hear anybody, but the last time that we were here, it appears to me that the two of you were talking about the possibility that this could come to some resolution. And you were looking at some numbers or something, I believe. Go ahead and update me on where things are at this point.
Ms. Jefferson, did you want to go first? So I'm happy to go.
Okay. Yes, Your Honor. We did meet, we did talk. We are asking for just a little more time, maybe approximately 30 more days. It seems that I subpoenaed the information from VA coordinators, the veterans coordinators, and it was due March 3rd. You know, I had called them prior to them, said would they take a subpoena by fax or email? They was gonna get back to me. They didn't, so I sent it by certified mail. I said the subpoena is overdue. They haven't responded. And I believe if once we get this information, we can resolve this matter. We had a long conversation yesterday, a long meeting with our clients, and it was, that's where we at, Judge. We really believe this matter can be resolved. We just need that missing piece.
Yeah,
Judge,
remember at the last hearing that was the missing piece. Mr. Washington, go ahead, sir.
No, I will concur and agree with counsel. I think she's made a good faith effort. We met with the clients, in fact, to kind of narrow the issues. We presented documentation regarding our cost and the contributions that were made by the Veterans Administration for the home care piece. And there's a veterans coordinator who is between the parties, and there seems to be some issue as to whether or not the coordinator may be holding funds or not. One way or the other, I think if they're holding funds that are due to our client, then we'll be able to receive them. If they're not, it would seem to vote in favor of our billing that we provided. And so to that extent, I'm agreeable to seek this information and see where we can go with it. But if it doesn't work out, that it's going to show that my clients have received everything, then the difference is owed by the other side, then we're going to be prepared to proceed to have this matter resolved by the court if we cannot agree. But for now, I think it's reasonable to request this opportunity to see what we can find out from the veterans coordinator in the middle, who's handling the funds in terms of paying the proceeds for the care that's been provided.
All right, yeah, that certainly makes sense. Mr. Jefferson, you think a 30-day window would might be beneficial here? Is this getting to a place where a show cause or something might be necessary? Go ahead, man.
Well, Your Honor, I think that if we could have 60 days would probably be the best, but if the court wants to just give us 30, I'm going to, and I intend to, because sometimes I'm at the court for exams, to ask the court to sign the subpoena. My clients did talk to the coordinators. They have the subpoena, but I don't know why you're not, because it was either produce the documents or show up in court. So it's like, what are you doing?
I would suggest 45 days, Judge.
Yeah.
Maybe we meet in the middle on that.
Okay.
Yeah, you're thinking in my head now. I'm gonna go ahead and set it actually for May the 2nd. That will give time, Madam Councilman, just in case we need the court to sign off on the subpoena. And if it starts looking like we might need to do something by way of show cause, I think that period of time will give us a better.
Okay, that would be great. What time?
2, and I'm setting this over for 10 o'clock a.m.
Thank you.
Thank you, Judge. Thank you, Judge.
Thank you. All the best on this. Appreciate the work that you.
Thank you, Judge. You have a good day. You have a good. Thank you.
Thank you so much.
All right, I'm back on the record in the suffix 1244. This is Westlake versus Nicole Whitaker. I looked at the file. It seems like the issues that might be raised here are as follows. Number one, a judgment was entered by default in this matter on March 25th of 2021. That judgment is against Ms. Whitaker for $7,066.90. That judgment comes as a result of the filing of a proof of service that indicates that Ms. Whitaker was served by attacking at 5748 Rush Street in the city of Detroit on 2621. That was a service that was allowed by the court. One moment here, and that was as a result of a second summons that had been extended, and that as a part of that second summons, the court did allow for service by alternate means, one of which was by posting. Subsequent to that time, the plaintiff sought to garnish the wages of the defendant at CVS Pharmacy, and the motion to the objections to the writ of garnishment is what is before the court today. It sounds like on the objection, it says, was never served with the writ, was not able to properly defend myself, it was without notice. The writ of garnishment would be without notice. There is no requirement that the defendant be notified regarding the writ of garnishment. So that does not provide a defense to the garnishment in this case. All right, so let me hear from Miss Whitaker, and I know that she is with her husband. I know that her husband is that they are consulting together. There's absolutely nothing with that. Let me hear from you, Ms. Whitaker, regarding this matter. How long has the garnishment been in place, and has any money been taken from you?
Good morning, Your Honor. I just like to say that I'm appearing specially, not generally, in this courtroom today. And the second thing is the garnishment has been happening for at least, I would say, 4 pay period cycles, or 3.
All right, and how much money has been taken from you per pay period, roughly, the range of what is
roughly, I would say at least 2, 3. I would say at least, I want to, at least close to 1,000 or more.
Per pay period?
Yeah, because one pay, depending on the pay period, one time they took 3 something out. It's sporadic. They don't take out the same amount. One time they took 3 something, one time they took 2 something, one time they took 2 something. They took close to 3.
Let me stop you for a moment. Okay, I want you to hear my question so that I understand it. So, what is the range that they take from you per pay period? That's what I'm getting at.
I don't even know. I don't have any paperwork, documentation, anything stating that the amount they're going to take out. Nothing. I have nothing from them.
That's not the question that I'm asking you. They've taken some money already, correct?
Yes.
All right. So the range of that, it sounds like you're saying to me is somewhere between, is it somewhere between 250 per period and 300, or something different?
Yeah, exactly what you just said.
All right, gotcha. All right. So why do you think that the garnishment should not be effective where there is a judgment in place?
Okay, can I share my screen with you, please?
Yeah, some of it, if it's talking about the underlying judgment, that's why I'm asking the question. If it's talking,
Yes.
You have to use a different procedure for that. That's what I'm getting at.
Okay.
I'll start out to tell me.
Thank you. I appreciate that.
No, go ahead. I want to hear at least the beginning of that to see. There are 2 things: pre-judgment, post-judgment. Pre-judgment is before it was entered. Post-judgment is after the judgment is entered. There are certain things that are pre-judgment that you have to use a different procedure to deal with. The matter that's in front of me, the objection to a writ of garnishment, is what's called a post-judgment proceeding. If you're attacking the pre-judgment proceeding, then there's a different procedure for that. So go ahead and tell me what you want to tell me, and I'll tell you where you are on the grid of that. Go ahead.
Alrighty. So I would like to challenge the jurisdiction of the court based upon the facts that the respondent that I was never served properly, nor given any notice prior to the suit against me. And I would like to ask the court to dismiss this judgment, dismiss the judgment against me because of that, without prejudice, because I was.
Gotcha. All right, so to raise the issues that you're raising now, you would have to go back before the judgment was entered. You have to file something that deals with the prejudgment. That is, you have to file something in the nature of a motion to set the default judgment aside, some type of motion to dismiss the case. You have to file something to deal with the prejudgment part. The issue that's in front of you today is post-judgment.
And I'm also objecting to the garnishment because amounts are different as well. One paper said we owe one thing, and another paper say owe another thing. And
we're gonna deal with all of that in just a moment. All right, we're gonna deal with that. That's why I asked some questions I asked you previously. But if you're going to try to set the judgment aside, you have to use a whole other different procedure. You gotta the court rules do not allow the court to look back at that unless you have a proper motion in front of you addressing prejudgment. This is post-judgment, right? So today we're dealing with the post-judgment objections that you raised. The objection that you raised in post-judgment, that objection really does not address post-judgment, it addresses pre-judgment issues. And so the objection is not a valid objection. Now, what it sounds like to me that you're saying is that even if the objection is not valid, you're asking the court to give you some type of relief as it relates to the garnishment. Is that correct, ma'am?
yes.
Counsel, let me hear from counsel, and then I'll address your request in that regard. Counsel.
Thank you.
Mr. Sirhan?
Yes, Your Honor. Now, as you're requesting regarding the objection, is that correct?
Yeah. My determination on the objection is that the objection is not valid. But counsel, Ms. Whitaker has asked that the court would give her consideration regarding the garnishment, and I believe that is a request for the court to consider a voluntary payment so that the garnishment can be lifted pending those payments. Go ahead, sir.
As far as that goes, Your Honor, it may be too soon to consider that, and the reason that I say that is because it's slightly too early to tell exactly how much money we're going to be receiving through the garnishment. We've received 2 pay periods, which were the pay period ending February 11th in the amount of $247.27, and the pay period ending February 25th in the amount of $288.66. We received 1 check for a total of $535.93. Now, that's what we've received so far. We haven't received anything subsequent to that, and that's just the timing issue of the way the garnishment works and receiving the checks and so forth. So just based on that limited information, I think it's difficult as of today at this time to set some sort of payment amount without having a bigger picture as to what we're going to receive via the garnishment.
All right, so it looks like you get paid every other week, ma'am?
I get paid every 2 weeks.
Every 2 weeks. All right. So it looks like you're being garnished. You're being garnished in excess of $500 a month. That's what the garnishment amount is coming to.
Basically, oh, sorry.
Yeah. Between $500 and $600 a month is basically what your garnishment rate is. So the way that this works is that basically what you indicated to me is that while this is pending, you're going to try to challenge the underlying judgment. But while this is pending, you like relief from the garnishment. Now, the way that you could potentially get that is by filing what's called a petition for partial payments. And when you file the petition for partial payments, what you put in that is the obligations that you have and what you believe impinges upon your ability to pay by way of the garnishment, and that you're asking to pay some lesser amount. If I was to, if you were to ask for a partial payment, how much would you be asking the court to set as a monthly payment, which you would pay once a month while this is pending? Again, can you?
Because you don't even know
If you're gonna talk, you gotta mute yourself because you're talking while I'm talking, all right? So you always mute yourself if you're talking, and then when it's time for you to talk to me, then you can talk to me. So what happens is that if the judgment is ultimately set aside, then what happens is any money that has been collected from you, you would have the right to have that money returned to you. In this case, if the default is set aside, if the judgment is set aside, then any funds collected, you'll get that money back because the case was quashed in that way. But while that judgment is in place, you got to pay something. Otherwise the garnishment stays in place, bank accounts can be garnished, et cetera, et cetera, et cetera. All right. So if you were going to ask for a monthly payment, what kind of amount would you be asking the court to set in light of the fact that right now you're being garnished at more than $500 a month? Go right ahead.
And also, like, they send it to the wrong address as well. So I don't have any proof that I even owe this debt completely or owe it.
All right, listen, I'm gonna do it like this. I promise you, I'm trying to help. And not because it's my job to quote unquote help you, but because I understand that within the context of the legal system, that oftentimes people don't understand what all of their rights are in terms of their money being taken right now. That's the part I'm dealing with right now. If you want to talk about all that other stuff, I can't even talk about that part of it. I guess that's where we are with this case. So until you file something with the court, the garnishment will stay in place. If you want to get some relief from the garnishment, file something, a petition for partial payments or something, and maybe you can get that amount reduced. My effort was to try to inquire as to what amount might work for you until you can get that, until you maybe get this case set aside. We've not gotten anywhere with that, and it's taken too much time. So the objections to the garnishment is not a valid objection that the court can recognize under the rules regarding the post judgment. You have the right to attack the judgment. You have a right also to petition for a way to pay the judgment voluntarily that may not amount to more than $500 a month. That's what I was trying to get at, but I see I can't get anywhere with that. So I'll deny the objections, and the writ of garnishment will remain in place, and the funds will be released to the.
Did you receive my affidavit?
Good day to you.
Did you receive the affidavit?
So, sir, have you received the affidavit that I put on record?
If you filed something properly, then it made its way to the court's file. And whatever you.
So how come that you didn't mention it?
Well, it don't matter if I mention it. And what I mentioned was what was relevant to this case.
We have valid reason to object to the garnishment.
Okay, well, when you get the role to decide that and make that decision, then you go ahead and make that decision. That's what you do. But you come here. It's my job to make a decision regarding your case, and that's what I've done. I made a decision on your case, and in fact, I tried to help you get to a place where you could probably pay $150 a month to take you off that $500 and something a month garnishment, but you're not interested in that. So good day to the two of you. I don't know why you have such a difficult time listening. Good day to you. That's the end of the hearing.
Thank you, Your Honor.
All right, this is case number 20-146674. This is Mimic Insurance Company versus Beverly Denise Moore.
Yes.
All I have of action is that the plaintiff, your appearance at this time. For Mimic Insurance Company, please, your appearance. All right, just one moment.
Yes.
Are you here? Are you? I haven't asked for Ms. Moore yet, so I'm really asking for Mimic Insurance. All right, let me look at something here. All right, the matter is before the court on the filing of objection to a writ of garnishment Looks like I don't have all of the paperwork in front of me. That's what the issue is. Just one moment. All right, your name for the record, ma'am.
Beverly Moore.
All right, thank you, Ms. Moore. Ms. Moore, you filed objections to a writ of garnishment that was issued regarding a default judgment that was entered against you. That judgment is $12,292.58. What is
Yes,
the
Your
basis-
Honor.
what is the basis of your objection regarding this matter, ma'am? Go ahead.
I never received anything stating that I was being sued or garnished until I went to the Secretary of State to renew my license.
All right. Well, those issues, ma'am, you have to raise that in a separate setting. They are what's called prejudgment issues. This is a post-judgment matter. That means the judgment has already been entered against you, and you have to address the issue of the money that is owed by virtue of that judgment. Now, you have the right to file a motion to set that judgment aside and ask that the court take a look at that. That's not up for hearing today. That's not something that's before me. And so the only thing that you can address now is the issue of garnishment. And so I take it that the garnishment is against your wages. Is that true, ma'am?
Yes.
So it looks like.
Yes, Your Honor.
Okay. All right. So where do you work, ma'am?
I'm not working. I have a fixed income from disability.
All right. And is that some type of federal disability that you receive, ma'am?
It's yes, it's from my COPD if I'm not able to work. And
you receive something from the Social Security Administration. Is that what it is, ma'am?
yeah, yes.
All right. So that those funds would not be subject to garnishment, ma'am. It sounds like what's going on here is that this is a income tax garnishment. Is that what it is?
Yes.
Okay. So are you expecting money back from the state?
Yes.
Right. How much are you expecting as return from the state, ma'am?
I just filed a week ago. It's not much.
Yeah,
I
that's what I
haven't received anything yet.
Right. And
It hasn't been put in to see how much I get back yet.
It's been prepared.
It's been prepared. It's being prepared.
And when it was prepared, did you look at the form to see what your expectation is from the state? Because the only part that would be subject to garnishment would be the state income tax return, not the federal or anything like that. The state income tax return. Do you have any idea how much money you would be expecting from the state income tax return?
I'm meeting with my tax preparer tomorrow when we was going to go over everything.
Gotcha. But you got some. Thank you. Just a second. I was talking to my buddy. I know. Here's what I'm getting at. I'm getting at the stuff that probably a little bit of common sense. Okay. How much money do you think you will get back from the state? What did you get back last year? Was it 100,000, 10,000, 2,000? Talk to.
I believe it was like I'll say $700.
Okay. All right.
Roughly around that.
All right. So that is subject to garnishment, man. So you have to do something there because you don't have a valid objection to the garnishment. So those funds can be taken by the by Munich Insurance. In the interim, what you could do is you could certainly file asking that the judgment be set aside because you indicate that you didn't receive a notice. And although the Register of Action says that in 2020 that the summons and complaint was personally served on you, but if you don't believe that occurred, you have the you have the right to file a motion asking that the court review that and potentially set aside the judgment in this case. You would also have to show that you have a defense. That is that Munich Insurance does not have the right to be suing you for anything. You'd have to kind of show that in order to get your motion granted. Right now, the writ of garnishment will remain in place because you don't have a valid objection to the writ of garnishment. But you still can file something on the second floor to try and get the judgment set aside. If the judgment is set aside, any money that's taken from you would have to be refunded to you. You understand?
Yes.
All right, so that's my determination in this matter, ma'am. And you'll get a copy of my order. And again, if you're going to try to get that judgment set aside, you will have to file something, usually called a motion to set the judgment aside. It's usually what you have to file. You do that on the second floor, 36th District Court.
Okay. Yes, Your Honor.
That's it.
Can I ask a question, please?
Yeah, go ahead, ma'am.
I had no idea my license was suspended. Is there any way I could like get my license where I can, you know, have my license renewed?
Yeah, and that's okay. I'm sorry. The type of case that was filed against you alleges something that has to do with driving, or that someone was driving your vehicle and some accident occurred. And when you have that type of judgment against you, the entity holding the judgment can file the same with the Secretary of State, and that will result in your license being suspended until the judgment is paid. So what has to happen is that if you get that judgment set aside, number one, that would result in your license being reinstated. Other thing is that you could potentially get into a payment agreement. If you don't get it set aside, you potentially get into a payment agreement with Munich Insurance, and they could stipulate to setting aside the suspension so long as you're making the payments on the judgment. So you would need to talk to someone at Munich. That's why I was hoping that their attorney would be here today, but the document that you have, you want to call that office and see if you can speak with someone regarding arranging a way for you to make a payment based upon your income, your limited income, and getting the suspension set aside while the payments are being made. But that's something you'd have to try to work out with them, all right?
Yes, Your Honor. Can I? Okay, I just want to say one more thing. I did try to reach out to them and I got no response. You know, prior to me just finding out about this, you know, this paper, this is my first time hearing about all of this. Is when I filed on the 8th to get my license renewed.
Sounds like you want to file a proper motion to see if you can get that set aside. You can also file a motion.
Yes.
You can also file a motion for partial payments as well, and ask that you be given the opportunity the suspension lifted. So you want to consider all of those things, ma'am, as you go forward here. Right? I do wish you well. All the best to you.
One more thing, I'm sorry, Your Honor. You're going to send me the information
From this court date.
for this court date, or do I just go there?
You're going to get an order from me. The order that you get from me is going to deny the objections for the reasons I stated. And then if you're going to do anything further, you need to go to the second floor and perhaps file to get either a partial payment or file to a motion to try to get that judgment set aside. Because your big issue is that there's a judgment in this case, okay?
Okay, thank you, Your Honor.
Okay, I wish you well. Good day to you, ma'am.
Thank you, you too.
All right, thank you for your patience. For those of you that are remaining, this is case number 21-153-471. This is Prism Lab LLC versus City of Detroit. And I'm looking at this while I see a 9:45 time set on it. Somehow it was down in the 10 o'clock. My deepest apologies for anybody that has suffered by virtue of waiting in here while you hear my shouting out a little bit. All right, your appearance for Prism Lab, please.
Good morning, Your Honor. Isabel Gavrilowski, P84492 on behalf of plaintiff.
All right, thank you, counsel. Good morning to you. For the City of Detroit, please.
Jane Mills, P38251.
All right, Ms. Mills, and thank you and good morning to you as well. Again, both of you, thank you for your patience in this regard. Now, I've seen this file a couple of times, and so.
We have good news. We have good news, Your Honor. We've took the time this morning in between listening to the arguments to resolve the case.
Is that right? All right.
Yes.
All right, that's about the size of it, Madam Counsel. You got it all worked out. All right, sounds good to me. So, what do you do next? Do you need city council approval on this, or you're able to work for it?
I think this is below city council's authority. So as far as this court's concerned, we'll submit a stipulated order of dismissal and I'll get the release and paperwork to plaintiff's counsel and then we're done.
All right, very well. I will mark the matter as resolved and glad that we were able to get it there. And I will await the stipulated order of dismissal.
Thank you, Judge.
Thank you, Judge.
Okay, bye-bye.
All right, this is case number 17-11-7522. This is ABC Auto Finance versus Prosina Denise Purifoy. The matter is before the court on the filing of objections to a writ of garnishment. For the plaintiff in this matter, please.
Good morning, Your Honor. Robert Zelinski on behalf of plaintiff P69250.
All right, thank you, Mr. Zelinski, and good morning to you. I'm looking now for Rosina Purifoy or Herring. If you're on the Zoom, please say something at this time.
Good morning, Judge.
All right, good morning to you, ma'am. These are your objections to the writ of garnishment. I noticed on the form it says you did not receive the unit of garnishment, the writ of garnishment. And you said you're head of household and low income. And this, is that a correct statement? What your objection is in this matter, ma'am? Is that true?
Yes.
So you work for St. John Hospital and the writ of garnishment was presented there. Is that true, ma'am?
Correct. I'm a nurse intern there.
All right, thank you, ma'am. All right, so the judgment in this matter, let's just take a look here. The judgment is in excess of $12,000. Your petition actually sounds like, actually I'm looking here, it says, just reviewing the file, give me 1 second.
Okay.
All right, so it seems like your petition is actually asking the court for some type of payment arrangement rather, because not receiving the writ of garnishment, that's not a defense to the garnishment itself. And when you point out that you're the head of household and low income, that's basically saying to me that I can't afford the amount that's being taken by way of garnishment. I'm asking the court for some other form of relief. That's what it sounds like. That about the size of this man?
Well, it's a few things. I don't believe that I'm responsible for the garnishment because that car was resold years ago and they told me that they was putting it up for auction, and then it comes up and I still owe money, and then they added on all these thousands of dollars on it. So I'm not really sure if I even owe that much money. I don't have that documentation anymore. But if we would need to do a payment arrangement, but I would really like to get this garnishment taken away or get the case. I'm not sure what I really need. I just really would like to get the case taken away or set aside or something of that nature. But until then, I would like to see if I can get a lower payment because I am a student intern and I am doing that part-time. So I don't really have a lot of income, and that was the only income that I was receiving.
Thank you. So the issue here is that the judgment was entered in 2016, and you've not filed anything to attack the judgment. And of course, the judgment amount and any interest accruing on that is why there is a writ of garnishment, because there's a judgment that says that you owe money. If you wanted to attack that, you needed to do it years ago. But even now, if you believe that you have a basis to challenge the underlying judgment, you can do that, but you can't do that in a post-judgment hearing. This is a post-judgment hearing. This hearing is only about the writ of garnishment and whether or not that's why the categories that you saw in that objection basically is stuff like I filed bankruptcy, the funds are exempt, I have an installment plan. Because basically what it's saying is that they shouldn't be able to garnish me because I'm already paying it some other kind of way, or I filed bankruptcy. If you attack the pre-judgment stuff, you have to file a different type of motion to try to challenge that. So anything that's in front of me today is the writ of garnishment situation. So has any money been taken from you from St. John?
Yes.
Right. And how many times?
It has been, I can pull up my check stubs to be exact, but I believe it's been about 4 times, 4 to 5 times.
Okay. And how much is roughly how much is taken each period?
Each period is between 200 and 400. Roughly. I'm not 100% sure because I don't have the documents in front of me, but I could pull it up if you would like me to.
Yeah, I'm going to try to find that out in a moment. So basically what you're saying is the garnishment is hitting you for about $800 a month, or between $400 and $800 a month?
Yes.
All right. And if the court was to consider a partial payment in this matter, how much money would you say to me that you should be allowed to pay this judgment at per month?
Per month, I can pay between 100 and 150.
All right, let me hear from Mr. Zelinski, sir. Go ahead, sir.
Sure, Your Honor. Yeah, there's been about 1, 2, 3, 4, 5, 6. 5, 6 payments we received. The first 4 were for $175. Then the last 2 was $228, and then $413. So I don't know if she had a bonus in there, some overtime or something. So it fluctuated, but 4 of them were for $175. So looking at it, I'd say, unless that was an odd bump on that 400, I'd say it'd be about $300 to $400 a month is probably what it would be. In all these cases with the objections with the garnishment, I offered to the defendant after the hearing to call me directly. I give my direct line and we could talk about it right after the hearing and talk about payment plans. I think in this case, we could come up with something. So if it's like 400 a month, 150, that'd be kind of low for my client, but in the ballpark, I guess.
Got it. All right, ma'am, let me ask you, do you have children?
Yes, I have a 3-year-old.
Oh, okay. Congratulations.
Thank you.
Busy. All right. So you have your own apartment or a home house, or what do you do?
Yes, I actually rent from a friend of the family, so I have a house.
Okay. And you have a vehicle, do you?
Yes.
All right. What other obligations do you have that are outstanding at this point that you could give me a brief summary of?
Outstanding, just like utility bills, but.
So you pay utility bills, correct?
I pay utility bills, yes.
Are you got any other creditors that you're attacking right now? Anybody suing you, any other judgments or anything?
No other judgments or suings or anything of that nature.
All right, ma'am. So what I'm going to do is the objections to the writ of garnishment that you raised is not a valid objection. So I'm going to deny the objection to the writ of garnishment. I will give you some relief from the garnishment. I'm going to set your rate at $175 a month, and I'll allow commencement of that on the 15th of April, 4/15, 22. So beginning on April the 15th, you'll have to pay $175, and you'll pay that each month, the middle of the month, and that will stop the garnishment. So I'm going to go ahead and sign an order stopping the garnishment, ma'am, or that's stopping or suspending it, I should say. That suspending of the garnishment will be contingent upon you making that payment on the 15th and each month thereafter. If you miss the payment, then the garnishment will be reinstated. And you still have the right to file to try and get the judgment set aside if you believe that you have a reason to have it set aside. You can still do that. This is just addressing the post-judgment situation, and this is giving you an opportunity to pay voluntarily, so that you're not subject to a wage garnishment as long as you make the voluntary payment. Do you understand?
Yes, thank you so much.
Right, and I'm going to sign orders in that regard, and I'm going to put you, Mr. Zelinski, so he can just go over where and how you might make your payments and things along those lines, so you're on the same page. Before I do that, Mr. Zelinski, anything you wanted to say, sir?
No, Your Honor, that's fine. Just as long as is the court marking all withheld funds to plaintiff?
The funds that have been previously withheld will be awarded to the plaintiff, and then the garnishment will stop immediately. And then getting the 15th of April is when Ms. Purefoy will make her first voluntary payment. And Mr. Zelinski is going to give you some direction in that regard. I'm sitting in the breakout room number 1, and I'm going to send you there as well, Ms. Purefoy. So you're going to get.
Okay.
Do you want us back, Judge?
No, you don't have to come back. I'm signing the appropriate orders.
Okay.
All right. Good day to the two of you.
Thank you so much.
Go ahead and click in, Mr. I see a couple more people here, and I wonder, Mr. Lowe, Mr. Jamali, I must have.
Yes, we are a match in the case.
Which case?
It is the Affiliated Diagnostics versus City of Detroit.
940. 940.
Oh. All right, this file is so big that I missed it. All right, how did that one go? All right, this is case number 21154940. This is Affiliated Diagnostic of Oakland versus City of Detroit. And the matter is before the court. I have it marked out as set for a pretrial conference. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Jamie Lowe on behalf of the plaintiff. My P number is 63110.
Thank you. And your appearance for the defendant in this matter, please.
Good morning, Your Honor. Chelsea Grimaldi for the defendant, P85585.
All right. Thank you, counsel. And good day to both of you. And I guess I'm noticing now that this was this was set for 10 o'clock. I'm glad you hung in there because I was sitting over there.
It's been an entertaining morning, Your Honor.
Yeah. Objections to garnishment somehow makes it very interesting.
Yes.
All right. So what's going on here? I'm looking. It looks like I see a motion, renewed motion to compel plaintiff's answers to defendant's supplemental interrogatories.
Yeah, I saw that this morning. I don't see that we have a hearing date for it yet, but it looks like it's basically a motion to compel more specific answers.
So, is this one of those cases where I said you filed your motion, I could be heard on this date, or?
Not that I know of. I haven't seen a hearing date for that motion yet.
Wait a minute, this is, yeah. All right, so, Madam Counsel, you're outside counsel for the city on this, or?
So I'm actually covering this hearing for my colleague Greg Pattison. He had to hop off Zoom to get to an expert deposition, so I'm not completely familiar with the case, but it's my understanding that we were just seeking trial dates from this hearing.
All right, got you, thank you, that helps a lot. All right.
I'm glad.
So I'm going to, it looks like with this motion here, I do have to set up a time for that to be heard. Hopefully the parties can kind of get that worked out before the motion hearing date. Because if there's some more specific answers, then I think we can work that out. So let me set it over for 30 days, and I anticipate setting this for trial, but in the interim, I will set it 30 days out for a hearing on the motion, and then I'll set trial dates and what have you at that time.
So will the court, Your Honor, will the court send out notice of that hearing date?
Yes, but I'm going to give you the specific date now. That date is
21st.
4/21/22, and that's at 10 o'clock a.m. 4/21/22, 10 o'clock a.m. And that's set for motion hearing and review.
Very good, Your Honor.
All right, thank you again for your patience, and good day to the two of you.
Good day to you as well, Your Honor.
Have a good day.
That's the thick one, so I'm sitting here, it's just, you really won't need it, just set. 21st, 22. Motion